This presentation will walk through a legal combat concerning a case of premature retirement at the age of 60 years, violating AICTE regulations, which prescribe the age of superannuation as 65 years. The brief background of this legal combat is that a faculty member of an AICTE-approved technical institution was issued a premature retirement notice at the age of 60. This was despite the AICTE prescribed superannuation age of 65 years. This notice was issued under the false pretext of a government resolution that does not apply to non-granted private technical colleges. The college in question is a private, self-financed institution, also referred to as a permanently non-granted college. It is important to note that this status exempts the college from certain government resolutions, but does not exempt it from AICTE regulations, which govern private self-financed technical institutions. The institution is affiliated with Sant Gadge Baba Amravati University. It operates under the regulations of the Maharashtra Public Universities Act of 2016. Hence, its actions are governed by AICTE norms and the university statutes.
According to AICTE regulations, the age of superannuation for faculty members is 65 years. This rule has been reiterated by Direction 50 of 2019 of the university. The institution's notice of premature retirement violated this regulation.
The aggrieved faculty member filed a writ petition in the Bombay High Court Nagpur bench under Article 226 of the Constitution. This legal provision allows citizens to seek remedy for the violation of their fundamental rights, in this case, the right to continue employment under AICTE norms. The first and foremost legal argument is that the college is a private, self-financed technical institution approved by AICTE and has been granted an extension of approval (EOI) every year. Under the AICTE Act of 1987, the institution is obligated to follow all the norms laid down by AICTE, including those related to qualifications, pay scales, service conditions, and the retirement age. The next legal argument is that, in addition to AICTE rules, the institution is governed by the Maharashtra Public Universities Act 2016, along with the statutes and regulations of Sant Gadge Baba Amravati University. These regulatory frameworks support the implementation of AICTE norms at the college level. In 2019, the university adopted AICTE regulations of 1st March 2019 through Statute Direction 50 of 2019 on 13 December 2019, which made these rules binding on all private self-financed technical institutions affiliated with the university. This reinforces the case that the faculty members should be allowed to continue working until the age of 65 years. The AICTE norms and standards are binding on the private self-financing technical institutions, is further affirmed by the Maharashtra Government Resolution of 16 April 2003. This GR has been issued in the backdrop of the Honorable Supreme Court 11-Judge Constitutional Bench judgment, dated 31 October 2002, which made the statutory regulations binding on the private self-financed professional colleges. The state of Maharashtra through its GR, dated 16 April 2003, following the said judgment, declared that the private technical institutions shall have to follow the AICTE norms and standards in their administrative affairs. The society managing the college received the extension of approval (EOA) from AICTE for the academic year 2024-25. This EOA is based on a self-disclosure affidavit sworn under oath by the society, affirming that they will adhere to AICTE norms, including the age of superannuation 65 years. The EOA was issued under AICTE 2020 regulations, which mandate that the institution follow all norms prescribed in the Approval Process Handbook (APH) for 2024-27. These norms include specific requirements for faculty superannuation, qualification, and pay scales. The EOA has an express mention of this statutory requirement. It is mandatory to comply with all the essential requirements as given in APH 2024-25 to 2027 Chapter 6. Clause 6.15 of the Approval Process Handbook explicitly states that the superannuation age for faculty members and principals is 65 years. This clause is binding, and the college and the society must comply with this and other AICTE norms. The AICTE regulations of 2020 concerning the grant of approvals to technical institutions, along with subsequent amendments, have been laid before both houses of Parliament. This provision under Section 24 of the AICTE Act of 1987 gives these regulations the force of law, reinforcing their binding nature on all AICTE-approved institutions. The AICTE regulations of 2020 Gazette notified on 4th February 2020 were laid before 17th Lok Sabha of the Indian Parliament in Session 3 on 16th March 2020. The AICTE regulations of 2020, Gazette notified on 4th February 2020, were laid before the Rajya Sabha of the Indian Parliament in Session 251 on 19th March 2020. In a similarly situated case, involving another faculty member from the AICTE-approved engineering college, the High Court granted a stay to the impugned notice of premature retirement. This precedent strengthens the legal standing of the aggrieved faculty member in the current case. The main respondents in this case include AICTE as the first respondent, the state of Maharashtra as the second one, the Directorate of Technical Education as the third respondent, Sant Gadge Baba Amravati University as fourth, the concerned society as fifth, and the college as the sixth respondent. Each of these entities plays a role in enforcing, or upholding, or regulating, or following the AICTE norms. The petitioner main prayers include a declaration that AICTE regulations have primacy over conflicting state government resolutions. The petitioner is also seeking the quashing of the premature retirement notice and a declaration that the petitioner is entitled to continue working until the age of 65, the actual time of retirement being as per the university ordinances. The faculty member has requested interim relief, including a stay on the retirement notice, allowing him to continue in service during the pendency of the case. This would prevent the institution and the society from enforcing premature retirement while the legal process is underway. Honorable Court granted a stay to the impugned notice of premature retirement, a case of otherwise termination, directing the respondents to maintain the status quo. Thank you, dear audience, for your attention. This case highlighted the importance of enforcing AICTE norms in private technical institutions and ensuring that the legal rights of the faculty members are protected. Goodbye. Have a great time.